Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast of the Antitrust Law section of the American Bar Association. I'm Derek Jackson, and today's episode is titled, Where Do We Draw the Line? The Intersection of the First Amendment and Antitrust under the Noerr-Pennington Doctrine. The Noerr-Pennington Doctrine is an important exemption to the usual rules of antitrust enforcement. And rooted in the First Amendment, it immunizes parties petitioning the government from antitrust liability, even when such activity might otherwise be considered anti-competitive. So in today's episode, we'll look at the important but perhaps less understood doctrine, including the Noerr-Pennington Doctrine's roots, its limits, and the nuts and bolts of how it actually gets applied and sometimes even litigated in practice. Joining me today is my co-host, Sergei Zaslavsky. Hello, Sergei.
Hi, Derek. And today we're very lucky to be able to welcome Abe Chang as our guest for the program. Abe is a partner at Norton Rose Fulbright. He's based out of Houston. His practice focuses on antitrust and complex commercial litigation. He represents clients in high-tech, energy, healthcare, and pharmaceutical industries, among others. And he's very active in the ABA. He is the vice chair of the Exemptions and Immunities Committee in the Antitrust section. And perhaps most relevant for today's program, he is one of the few lawyers who has actually tried a case involving the Noerr-Pennington defense. So it brings a great perspective on the issue. Abe, welcome to the program. Great to have you.
Thanks, Sergei. It's great to be here representing the Exemptions and Immunities Committee. It's probably not interesting to everyone, but it's interesting to me, and so I'm glad that I get to talk about it today.
Awesome. Well, we're very happy to have you. Now, Derek explained a little bit about the Noerr-Pennington Doctrine in the introduction, but could you give us a little bit more of an overview? What are the basics of what this doctrine, what conduct does it protect?
Sure. And Derek got it right. At a high level, the Noerr-Pennington Doctrine says that private parties who petition or lobby the government are immune from antitrust liability, even if those actions are intended to or actually do result in harm to competition. It's an example of competing policy goals. The doctrine itself is grounded in the First Amendment's right to petition the government, and it creates friction with the antitrust laws, which want to protect competition. This immunity extends to petitioning or lobbying activity that targets any branch of the government, so the legislature, administrative agencies, and the courts. So examples of protected conduct would be lobbying for legislation, lobbying members of the executive, an agency, filing lawsuits, petitioning government agencies like the FDA, or filing for patents or challenging them with the U.S. Patent and Trademark Office. Those are all types of conduct that would be protected under Noerr-Pennington.
So I think you touched on this a bit, Abe, but what are sort of the historical origins and underpinnings of Noerr-Pennington? You know, why do we have this doctrine in the first place? What are the values it's intended to protect? And maybe why is it called Noerr-Pennington?
Sure. So this is the history nerd in me coming out. The doctrine goes back over 60 years now to two Supreme Court cases. And the first case is a mouthful, Eastern Railroad President's Conference versus Noerr Motor Freight. That was decided in 1961. To set the scene, we have a group of railroad companies that got together and they hired a PR firm to run a campaign against the trucking industry. And the railroad companies, they were lobbying the Pennsylvania governor to veto a bill. It was called the Fair Truck Bill. And what that bill would have done is it would have increased the weight limit that trucks could carry on Pennsylvania roads. And the railroad companies didn't like that because that would allow the trucks to compete more effectively against them. You know, a higher load per truck means that it's more cost effective, which means that the railroads are under greater pressure. And this campaign was actually pretty effective, and the Pennsylvania governor did, in fact, veto the bill. And so the truckers weren't happy about this, so they sued the railroads under Section 1 and Section 2 of the Sherman Act, the federal antitrust laws. And what their argument was is that the railroads were trying to monopolize the long-distance freight business. And the railroads came right back, and they turned around and they countersued. And they said, oh, hold on, the truckers are the ones who are engaging in anti-competitive acts because they're lobbying for this bill, this fair truck bill. And so what the Supreme Court decided was that there's no violation of the Sherman Act if it's based on mere attempts to influence the passing or the enforcement of laws. And the court went even further, and it said that it's not a violation of the Sherman Act if the restraint on trade that you're looking at, or the monopolization, the anti-competitive conduct, is the result of government action as opposed to private action. And so that's Noerr, 1961. Fast forward 4 years to 1965, when the Supreme Court decides United Mine Workers versus Pennington. And that case involves a group of large coal companies, big coal, let's call it, and the mine workers union that was working in all these mines. And they allegedly got together and they conspired to restrain competition in the coal industry. And they tried to do this in a couple of different ways. The two main ways they tried to do this: one, they approached the Secretary of Labor to establish a minimum wage in the coal industry. And then they also approached the Tennessee Valley Authority, which at the time was buying some of this coal, and they asked it to stop buying coal on the spot market. And that mattered because a lot of the coal at the time available on the spot market was being produced outside of the confines of these large coal companies and the statute that they worked under. And so this would have the effect overall of killing the small coal operators out there in the market. And one of the smaller coal companies sued. And this went to trial. A jury agreed with the plaintiff, Little Coal, if you will, and granted it damages on its case. The trial court poured out the case against the large coal companies, but kept the case against the union workers. And that's what ended up making its way to the Supreme Court. And what the Supreme Court held there is that it doesn't matter what big coal and the mine workers were intending. It's not an antitrust violation to lobby officials, even if the whole point of that lobbying is to kill the competition. And so that's where this doctrine is born. You have these two cases, Noerr and Pennington, and that's where you get the name Noerr-Pennington. And as we discussed just now, it's an example of the type of friction that you encounter when you have important and sometimes competing policy goals, like freedom to petition the government and the antitrust laws. It's important to be able to petition the government, to be able to go to the government with what you want, but it's also important to protect competition. And in this particular case, the First Amendment wins out.
Yeah, and that's, I think, a really interesting point. So you have, these competing policy goals, and at least in certain cases, maybe involving clear kind of First Amendment activity, like petitioning, lobbying the government directly for a piece of legislation or a regulation, the First Amendment wins out. Are there circumstances where the antitrust laws went out? Are there limits to this exemption that was created in Noerr-Pennington, or is anything a company can kind of do and say, we are petitioning the government for this covered?
So there are definitely limitations to the immunity, and that's something that was built into the doctrine when it was born. The Noerr court recognized there could be situations where the petitioning was a cover-up, let's call it, for any competitive activity. And in those situations, the court said the immunity doesn't automatically extend to any activity that we want to call petitioning. Right? Activity that's a mere sham is what the court said. Activity that's a mere sham to cover up what is actually nothing more than an attempt to attack a competitor, that's not protected. And so that's the origin of the sham exception to the Noerr-Pennington doctrine. And, the case law has evolved over time since, 1965. And, The case law has, changed a little bit on how far the immunity extends. It's clarified a little bit what kind of conduct is protected, what is not protected. There are two major cases to mention. I think there are others out there, but the two major ones that I can think of are California Motors and professional real estate. And California Motors was a 1972 case, so less than 10 years after Pennington, and it involved truckers again. So this time, the truckers are the ones that are trying to keep out the competition from other truckers. Basically, a group of truckers in California were using administrative proceedings and court filings to keep other truckers from getting rights to operate in California. They were trying to protect what they thought was their monopoly, their territory. And the interesting, twist here is that the defendants were doing this as a pattern. They were launching these administrative proceedings and filing these filings without any regard for whether they had a case or not. And what the Supreme Court said is that you can't abuse the process through a pattern of baseless, repetitive claims. That's not the type of petitioning that's protected under the Noerr-Pennington doctrine. And it's interesting and I think notable that over half the time, the defendants were actually winning their administrative proceedings, right? So this isn't like they were just hauling off and filing all these cases and losing them. Over half the time, they actually won. The point here was that it didn't matter if not all of the proceedings were baseless. It's the fact that the defendants didn't care whether they won or lost at all. They just wanted to use the system to create costs and delays for their competitors. And so that spawned a series of cases. The other case that I'll mention is professional real estate. And that's, I believe, the current test for the sham exception to the Noerr-Pennington doctrine. Of course, other circuits have clarified and tried to grapple with what this case also means, particularly in the context of California Motors. But, just for a quick background of professional real estate, that's a case that involved a lawsuit between a film company, Columbia Pictures, I think we're all familiar with the brand, and hotel owners. And the film company, Columbia Pictures, sued the hotel owners for copyright infringement, something about playing films in the hotel rooms. And the hotel owners countersued for antitrust violations, and they said the copyright lawsuit itself was just sham. So it was not protected under the Noerr-Pennington doctrine. It qualified for the sham exception. The Supreme Court articulated a two-part test here. It said, first, the lawsuit must be objectively baseless, and that means that no reasonable litigant could realistically expect success on the merits. And you look at that test, and only if the lawsuit is objectively baseless do you then move on and you ask, all right, what was the litigant's subjective motivation here? What was it trying to do? Right. So if the litigant has an objective basis for thinking that, if I file this lawsuit, I can win, then you don't even get to the subjective intent. And so, just to go back to your original question, not all petitioning is protected. A lot of it is. But if you're using government process as a weapon, you should take a closer look at whether the immunity applies.
And one of the things I find really interesting about Noerr-Pennington doctrine is that it protects not just the petitioning activity itself, but also at least some activity incidental to the petitioning. And I think one of the real tricky questions, especially when you counsel clients about what they can and can't do, is how far does this protective umbrella extend? What is incidental activity that is protected and what activity is not covered by the doctrine? How do you tell the difference? What pointers would you give somebody who is trying to counsel clients on what they should and should not do?
It's so hard to draw bright line rules around Noerr-Pennington because it's so fact specific and nuanced, right? Think about the different contexts in which this conduct arises. You're talking about what you might be petitioning the FDA for a particular drug or for a competitor's drug to be excluded from the Orange Book. You might be petitioning for a series of patents that protect a particular area, but that in effect wall off competitors from joining that area, right? A patent thicket. It could be something along the lines of, filing a lawsuit. It could be petitioning, the legislature to pass a law to grant you a monopoly, right? Those are all different types of petitioning activity. And so it's very fact specific. That said, I would say, not to bring it back to law school torts, think about causation. Causation matters here, right? What is causing the harm? If you're about to engage in petitioning activity, make sure you understand, how would a competitor be harmed here, right? Is that conduct coming from government action? Or is it coming from private action? If the conduct is coming from government action, then the immunity applies. If the harm is coming from a private entity, let's say, then it's not protected. Separately, I would just note that if you're about to engage in a pattern of petitioning activity, know the law of your circuit. Lower courts have tried to square the pattern exception that was articulated in California Motor with the test in professional real estate, and it's been a bit confusing overall. I think the question for most courts is whether you apply this objective and then subjective two-part test if you have a pattern of conduct, right? Because in essence, if you were to apply that objective standard to every single instance in that pattern, you might have just killed the pattern exception altogether, because if you can establish the objective standard and also meet the subjective standard, then you've got it. Each instance would qualify for the sham exception already, right? So what's the point of having a pattern exception at all? The majority view, I think, is that the two-part test in professional real estate, that covers single instances of conduct. And California addresses an exception, the pattern exception, if you have a pattern of conduct, right? But that's not true in every circuit. I think maybe the First and the Seventh apply the objective analysis to each instance in a pattern, and that makes it a lot harder to prevail on or to demonstrate that there's a sham exception here. So depending on what circuit you're in, you might have a much more insulated case if you're about to engage in petitioning activity.
Got it. Well, very useful. Thank you for that. It sounds like if you're engaging in a pattern rather than just isolated single act, you should really take an even closer look for potential liability. So as we mentioned in the introduction, you actually tried a case that involved a Noerr-Pennington defense. And I personally find trial experience to be so illuminating on any issue because so much of litigation is trying to position yourself for trial. But so few cases actually go to trial that lawyers who don't try an issue, they know how to position it for trial, but they don't get that lesson from trial. Okay, this worked well in positioning it. This did not work well. So I find that trial experience really provides great insight, not only on how to try a particular issue, but what steps earlier in the litigation actually bear fruit at trial and which do not. So with that said, can you share with our listeners some of the lessons you learned from your trial experience? What works for preparing a Noerr-Pennington defense or opposing a Noerr-Pennington defense, and what may be less important?
Sure. So we all know that Noerr-Pennington issues are often decided on the papers. If you can prevail at the motion to dismiss stage, you will. And if not, you probably will re-urge at the summary judgment stage, but it doesn't always happen, right? And so I got to try a case where the Noerr-Pennington issue got to trial. And in that particular case, this is not exactly revolutionary advice, but I would say make sure you're uniting all of the themes in your case, including the Noerr-Pennington theme, so it's telling a coherent story, right? Noerr-Pennington issues often crop up in the context of patent litigation. And sometimes the party that's been accused of infringing, stealing the patent or the IP, so to speak, is the one that countersues and argues that the lawsuit itself is part of an anti-competitive scheme. And so you want to make sure you've got your story straight. You want to make sure that your patent themes, that your client is an innovator, that they don't steal IP. In fact, they're the ones who are being aggrieved here. Line up with your antitrust themes, that the other side is the one that is abusing the process, is using the process in a way that's unfair. So you want to turn your defense into offense, and you want to make sure all of this lines up in a way that is convincing, if it's a bench trial, to the judge, and if it's to a jury, to the jury.
Abe, I think one interesting thing to talk about would just be, some of the recent developments in case law or otherwise, just areas where you're seeing Noerr-Pennington issues crop up frequently in current practice. I know you spoke a little bit about some of the circuits struggling with, how to apply the Supreme Court law on the sham exception, but are there any other interesting case law developments or areas where this has become an important issue in practice?
Sure. So, I wouldn't say that Noerr-Pennington cases crop up all that frequently, but one that caught my attention was at the end of last year, there was a case in the Third Circuit. And in that case, I think answered a particular question. Is there a misrepresentation or fraud exception to Noerr-Pennington? And I think the answer in the Third Circuit is that there is not. That case involved the drug maker, as far as I'm aware, the only maker of mumps vaccines at the time. And there were some questions about the shelf life of the mumps vaccine. And the FDA flagged this to the drug maker, and the two worked together and tried to resolve it, but it did not, in fact, resolve the issues. And the drug maker didn't actually disclose that these issues hadn't been resolved, didn't disclose it to the FDA. It was concerned that the FDA would make it change the vaccine's label, and it didn't want to do that because it was concerned there was going to be another drug maker entering the market soon, and it didn't want that competitor to be able to demonstrate equivalence or that its vaccine was just as good. And so when this all came out, the competitor sued, and it said that, hold on, you've been lying about the shelf life for this vaccine. You failed to disclose that there were issues here to the FDA, and all of that, delayed our launch of the vaccine by years. And so, the question is, was this protected conduct? And the court ruled that it was, that there is no misrepresentation or fraud exception, that this is petitioning activity. And I don't think that the court necessarily framed it in quite the way I just described it, that there's no fraud exception. But in essence, what it did was it looked at the petitioning activity, it looked at the harm, like we discussed earlier, where was the harm coming from? And it concluded that the harm was coming from the FDA's decisions rather than the drug maker's acts, that it was petitioning activity that resulted in the FDA making decisions that then harmed the competitor. So for that reason, it decided that Noerr-Pennington applied, there was immunity here.
That's really interesting. So, it sounds like one key takeaway is really when it comes to the sham exception, or perhaps the fact that there's not a fraud exception, there's there's an important distinction between whether the harm is coming from the government or from the competitor's, use or abuse of the process, so to speak.
I think that's exactly right.
I think one close cousin or related doctrine that often gets invoked, maybe in conjunction with or in similar cases to Noerr-Pennington, is the state action doctrine. Do you want to talk a little bit about that and the distinctions between those two doctrines?
Sure. Well, I don't want to, steal the thunder from someone else that wants to talk about this as part of another podcast, but I'll cover it at a high level. I might want to, have a different podcast talking about state action doctrine. There's a lot to talk about there. But it's another antitrust immunity doctrine that's often invoked alongside Noerr-Pennington, and you can imagine why. The state action doctrine, in essence, grants immunity to state governments and, in some cases, to private entities that are acting under state authority from federal antitrust laws. This happens a lot, the intersection of state action doctrine and Noerr-Pennington in the context of healthcare and other industries, where you have state regulation And an example of that would be where you have a state, institution that provides the doctors, it's training them, it contracts them out to a private hospital, you have a private-public partnership. And in that scenario, if the private hospital is also, petitioning the state institution for certain acts or for exclusivity or something like that, you might see an intersection where Noerr-Pennington would apply because you are petitioning for certain rights or exclusivity, and also the state institution is, arguably supervising you, and you could have state action immunity that way. And big picture, if you are a private actor that wants the immunity, you have to show two things: that you're carrying out state policy that, one, has been clearly articulated, and two, is actively supervised by the state. And we're seeing more activity from state legislatures now seeking to immunize private parties from the federal antitrust laws. The Louisiana COPA case comes to mind. And so this is something to keep an eye on. I think we're going to see more of this as state legislatures get involved, are more aware of antitrust policy, want to create antitrust policy specific to their state, and they want to protect private parties from the federal antitrust laws.
Great stuff, Abe. And I know that Noerr-Pennington and state action both come up a lot in practice. So I think this conversation is not only interesting, but also of a lot practical significance, practical usefulness for our listeners. So I hope the law students and the younger lawyers that are listening to this have been taking notes. This stuff might actually be useful in your practice. So before we let you go, we usually like to ask our guests a couple of questions just to give the audience a chance to get to know them a little better on a personal level. So Abe, could you tell us something interesting about yourself that people who only know you professionally might not know?
Sure. So as it turns out, my name on my birth certificate is not actually Abraham. My parents are Taiwanese immigrants, and at the time, their command of the English language was dubious, let's just say. And so when my folks chose my name, my mom asked my dad several times to make sure that he had my name spelled right. And heading to the hospital, my dad's super confident. Yeah, I've got this. So my parents are in the hospital in Atlanta, and I've just been born, and the nurse asks him to write my name down, and he does. And the nurse looks at him and says, "Are you sure?" And he's like, "Yeah, of course I'm sure." And no one notices. So 5 years later, you can imagine my mom's surprise when my elementary school principal pulls her aside and very kindly explains that Abraham isn't spelled Arbraham. It's spelled Abraham. And so she still brings that up to my dad to this day when they have a disagreement. And some of my friends still call me Abraham.
Well, maybe we should have introduced you as Abraham on the podcast.
You know what? I still answer to that name as well. So that would be totally fine.
All right, Abe. And now we're going to do a little segment that we like to end our podcast with called The Curious Hat.
And now it's time for The Curious Hat!
All right, so in the Curious Hat segment, we draw a question from a virtual hat, a random question to ask you to get to know a little bit more about yourself. So I'm going to ask you to pick a number for me between 1 and 21.
So this isn't like the Sorting Hat. I don't get to ask for Gryffindor.
Maybe it'll reveal something deep about yourself in what Curious Hat question you choose.
Let's go with Lucky 13.
All right. What was the last movie you saw, and what did you think of it?
Oh my gosh. I unfortunately don't get to see too many movies. Oh, you know what? I know exactly what I saw. We watched K-pop Demon Hunters after several recommendations from my friends, and I was skeptical, but it's a certified banger. It's a really fun movie, and the songs are great.
All right. I've heard actually a lot about K-pop Demon Hunters in the very vague sense of like it's a big hit right now among maybe the younger crowd, among Gen Z. What is it?
It's really hard to describe. I would just say you got to watch it, but it follows a trio of K-pop stars that are actually, I don't think I'm spoiling this for anyone, but they're actually demon hunters. So I guess it's in the title. Of course, it's not spoiling it for anyone, but yes, it follows this trio of demon hunter K-pop stars around as they fight evil.
All right, so maybe a little mix of horror and musical. Yeah,
it's not even really horror. It's I think it's pretty akin to one of those Disney movies, right? It's got, if you're a kid, it's probably awesome, and if you're an adult, you're surprised at how awesome it is. So it really does strike that balance pretty well. There's, I would say, fairly universal appeal.
Great. Well, maybe we'll have to check it out.
You might want to watch out, though, because if your kid gets into singing it, then you're going to be listening to it for like the next 6 months. So,
well, that might not be the worst thing. I've been stuck on a Frozen loop for the last 6 months with my toddler.
Well,
so something to break up the monotony.
then yes, I actually would highly recommend it then.
Well, Abe, thanks very much. This was a really interesting discussion, and I think it's going to be really useful to our listeners, as Sergei said. So thanks for coming on the podcast.
Thanks for having me.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.